Hello. Sorry, I'm muted. Yes, here I am wandering away. Thank you. I was so excited. I got a bit ahead of myself. Hey, I apologize for that. Yes, we have a decision. The judge has made her findings, and I want to have. I keep muting myself. Shh. I got a bit excited. So, yes, we have a decision from the court for the motion to compel. And as I said, we were getting towards the D-Day. So if you are just joining us, we have got a court document. So we are just going to have a look at this page first, which shows us that there are two documents filed. There is a notice of the filing, and then there is the order. So it was about, so this is a decision that was made based on this in-person hearing here. Okay, so I've got them here, sitting here. So this is we've got here, we have got, yeah, I think. So we've got this one here, which is a file copy to say that we have, yes, Autistic Trail says I've been taking some of EKC's forget to unmute classes. Yes, usually I have everything unmuted, but as I said, I think I got a little bit excited by what's happening. So it says you are notified on the January 29th, 2024, the following was filed. Order on motion to compel. That was the order that was done. And interestingly enough, it says that it's gone to Amber and it's gone to Graham. Hasn't gone to her other lawyer, interestingly enough. So here is our motion. Here is our decision. So let's have a read of it. It is 5 pages. The above mentioned matter, and I'm going to get rid of myself here because you don't need to see me. You need to read to have like the karaoke ball. So this is order on motion to compel. So filed. So this was, I love this, AKA, Katie Joy. So 7M Films, Inc., Robert Shin, Miranda Derrick, James Derrick, plaintiffs versus or and. We don't, in written, you always put verse or against. But when we talk about it when we talk about cases in law, we'll say 7M Films, Robert Shin, Miranda Derrick, James Derrick, and Katie Doe, Catherine Mansky Paulson, aka Without a Crystal Ball. So you don't ever use the verse or against. You don't really say that. It's always and. When it's spoken about, we refer to it. So when you're before a judge and you're talking about cases, that you always use the word and. Just a side note there, which, just a side note. Yeah, and I'm sorry I didn't get any notification because I just checked and thought it was all up and I just got really excited. So unfortunately, I'm still home. So I'm glad that Her Honour was able to in my time frame. So let's scroll down. The above mentioned matter came before the Honourable Hari Willis, Judge of District Court, hearing on the 15th of November 2023 on the parties' motion to compel. Stavic appeared on behalf of the plaintiffs. Jennifer Moore appeared on behalf of the defendants. The court held a phone conference with the parties prior to the hearing and requested they meet and confer to narrow the pending discovery disputes. The parties submitted correspondence to the court on the 30th of October 2023 regarding outstanding discovery disputes. The parties presented oral argument to the courts on November 15, and the court took the matter under advisement as of that date. Based on the files, records, and pleadings herein, the court makes the following. So we've started off with the very basic. This is how we've got to where this is really what happened, okay? That we're dealing with a dispute over discovery. The court said, well, make it so that you can discuss it, try and get it all sorted out beforehand. I don't really want to have to intervene in this, but here we go. So this is now, we get to findings of fact. Remember, and she's got there based on files, records, and pleadings. So these are the facts the judge has found on the facts, not from sources, not from hearsay, on fact. Well, yeah, some hearsay is admissible. I don't know why my screen is moving around like it is because I'm not touching it. All right, I'm just waiting for it to settle down. Okay. Plaintiffs Films is a talent management company, and Robert Shin is its CEO and sole owner. Plaintiffs Miranda and James Derrick are husband and wife and associates of Mr. Shin. Fact. Plaintiff's business is in the field of social media communications and marketing. Additionally, they broker deals between performers, particularly dancers, and commercial venues. All right? Ms. Paulson runs several social media accounts with substantial reach, numbering in tens of thousands of followers, particularly on Instagram and YouTube. Notice it doesn't say an influencer, doesn't say she's a whatever. It just says that she runs social media accounts. Fact. Okay? Instagram and YouTube. Okay, fact. Plaintiffs allege 9 causes against the defendants. The first 2 for defamation and defamation per se, underlying the remaining counts. In summary, the plaintiffs allege that Ms. Paulson, via Instagram page and other social media platforms, defamed the plaintiffs by posting false statements about 7M and associated individuals. Plaintiffs maintain, just lost my second screen. Plaintiffs maintain that Ms. Paulson's social media posts claim the plaintiffs are involved with Shekinah Church, which plaintiffs argue that Ms. Paulson characterized as a cult. Plaintiffs further claim that Ms. Paulson has acquired and published court documents subject to a protective order involving the plaintiffs, and that Ms. Paulson has stated the plaintiffs engage in criminal conduct, including human trafficking, waterboarding, and kidnapping. It's not just 7M she's accused some of that of just recently. Plaintiffs' other claims are rooted in the same allegedly defamatory conduct by the defendants, but are pled as tortious interference with contracts, intentional interference with prospective advantage, deceptive trade practices, negligence, and intentional infliction of emotional distress. Okay, so now we're getting to conclusions of law. So that's sort of now where we've got to. So now the judge is going to tell us what the law says before she gets to her final outcome. In fact, these are very short. Australians' laws, usually Australian judgments have, they tell you what both sides argue, and anyway, we still might get that yet. Rule 2602 of the Minnesota Rules of Civil Procedure governs the scope and limits of discovery. It states in pertinent part, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defence and proportional to the needs of the case, considering the importance of the issues at stake, the amount in controversy, the party's relative access to relevant information, the party's resources, important discovery in issues, and whether the burden or expense of proposed discovery outweighs its likely benefit. That's the Rules 26.02. So essentially, if it is essential to the needs of a party may request it, is essentially what that's saying. And the court may limit discovery that is unreasonable, cumulative, or duplicative, obtainable from another more convenient source, or unduly burdensome. So in here now there is a case that it was quoted in and probably applied to. So then if you can get your information from another source, then they're saying, well, then you'd have to request, you don't request it. All right. It is more than likely, though, some of the discovery that they've asked for, they want to see whether it's been deleted or not, which would be interesting. So if you've already got information, the court can't make the other party give you the information that you already have, essentially. So we're up to page 2. All right, let's go to page 3. How are we understanding this at the moment? I don't know why the writing is so. I'm going to stop sharing and I'm just going to reload this, I think. See if we can make this any better. So is everybody okay? Look, I haven't even brushed my hair. I was just sitting, minding my own business. How are we so far? We've got it all. We understand where we're up to. I think I might try something else for this one. This is annoying me a little bit. All right. I'll put it in Chrome, I think. All right, here we go. This might be easier. All right. Okay. Oh, this looks better already. All right. Good. All right, I'll keep going. All right. So we've done that. We've done page 2. We're up to page 3. Right. So, well, that's the thing. But the hacking has not been. The thing is, Ginger, the hacking claim has only occurred after this last court date. So they've put here plaintiff's interrogatories here and requests for production. Plaintiffs have demonstrated that requested information relates to claims and damages asserted in this lawsuit. By her own admission, Ms. Paulson has a massive social media presence and has discussed plaintiffs on several platforms. The sources and veracity of that information is relevant to many of the claims asserted by the plaintiffs. The information is not overbroad, as it is limited to statements made and information obtained about plaintiffs within a specified time period. Defendants claim that plaintiffs are not entitled to too much of the information sought by plaintiffs because of journalistic privilege and or because information qualifies as journalistic notes. The issue of whether or not Ms. Paulson is a journalist has not been presented to or decided by this court. Let's just look at that. The issue of whether or not Ms. Paulson is a journalist has not yet been presented to or decided by this court. Yes, autistic, sure, there'll be more hacking. Yep. I still don't understand why, if her old Facebook was hacked, why her Instagram wasn't hacked at that time. Oh. To the extent the defendants maintain that sources of some of this information are confidential informants or qualify as journalistic notes, they can provide that information to plaintiffs pursuant to a privilege log in accordance with the Minnesota rules. So yes, journalists have to submit their source information, and they can do so without going sources. So let me just repeat that. To the extent that defendants maintain that the sources of some of this information are confidential informants or qualify as journalists, they can provide that information to plaintiffs pursuant to a privilege log in accordance with Minnesota Rules 2602F. Plaintiffs' requests for productions 17 and 18. The court finds this information to be discoverable. The issue of whether defendants were compensated, how much they were compensated, and by whom they were compensated from January 2020 to present is relevant to the defendant's motives in discussing plaintiffs on social media platforms, including the depth, length, substance with which the plaintiffs were the focus of Ms. Paulson's discussions. So, if she's made any money from those posts, it's relevant. Similarly, these requests for 19, 20, 21, 22, 19, 20, 21, 23, 24, these requests are discoverable as they relate to defendants' motives in potentially gaining financially from their discussions regarding plaintiffs. Defendants offer no legal support for their claim that the production company would be required to make an independent argument regarding the disclosure of any contracts they entered into with the defendants, and does not find that argument persuasive. On 6 and 7, these interrogatories are written as overbroad. Defendants contend that they are seeking evidence of statements against interest. However, the interrogatories are not limited to statements against interest, nor are they related to a specified time period. Furthermore, they do not identify the general substance of the statements the defendants are seeking. So they haven't got, looks like they haven't got, these are the defendant. So this is the plaintiff. So, yes. So defendants, so the stuff that Katie Joyce requested has been denied. These interrogatories as written are overbroad. Okay, defendants. They don't identify the general substance of the statements the defendants are seeking. Defendants interrogatory 8 is also overbroad as written, as it is unanswerable in its current form. Defendants stated they would limit communications to communications about the lawsuit or claims in this litigation, but the interrogatory seeks information prior to the commencement of this litigation. Defendant's limitation does not render the interrogatory answerable. So at the moment, everything that 7M wants, they're entitled to get. Everything that Katie Joy has asked for, she's not going to get all of them. So for 10 and 8, these interrogatory requests information relevant to the claims or defences in the lawsuit. So she can have 10 and 11. Interrogatory 12, this interrogatory is overbroad and not likely to lead to discoverable information. Defendants interrogatories 14, 15, 16, 17, 19. These interrogatory request information relevant to the claims in the lawsuit. So she can get those. And defendants' request for production 6 and 7. This request is relevant to the claims or defences in this lawsuit, but should be limited to the time period from January 2020 and to the present. So she's saying, yep, you can have it, but only to the time frame of this lawsuit. Defendants' requests for 8 and 16. These requests are overbroad as written, and defendants have not demonstrated that they are relevant to the claims. Defendants' requests for 19, 14, and 20, they are relevant to the claims and defences in this lawsuit. Plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. Defendant's motion to compel is granted with respect to interrogatories 10, 11, 14, 15, 16, 17, and 19, and requests for production 9, 14, and 20. and granted in part with respect to requests for production 6 and 7. The remainder of the defendant's motion to compel is denied. The parties shall continue to abide by the protective order entered in on the 7th of February 2023. This matter remains set for a live conference schedule on March 19, 2024 at 9 a.m. So that is our order. So essentially, 7M got all of their discoveries. Katie Joy got some, but not all. So what are your thoughts on that? A lot of the stuff she was claiming, about 7M has been found to be her. She has not. They often said this was overbroad and we don't need to compel. But I think the biggest line to take out of this is that this judge has said that the court has not determined whether she is a journalist or not. Oh, and I think that's the... Have I just gone off live stream? Am I live or not? Are you there? I don't know what's happening. Because usually I have a little red light to tell me that I'm live. So anyway, I'm sorry. So here's the thing. Do you think we're going to get some manic posting now? Or is she going to go on the record and try and correct to say, no, you're here, autistic, sure, that's all right. Or is she going to say that people that don't know what they're talking about are not interpreting legal documentation correctly? How is she going to do this? Or are we going to just see more manic posting? Because since this is... Because what is it? Monday morning, isn't it? Yeah. It's Monday in the US, isn't it? See, didn't I said last week that there had to have been something in the works for her manic posting. And it wouldn't surprise me whether they had an inkling of what was going to come first. And so she's just gone and she's just gone over. That's sort of my thing, is that she sort of knew it was coming. And she's gone into absolute crazy mode. Just another drunken Monday, oh. Wish it was Sunday, oh, 'cause that's my fun day. Oh, gee whiz, hey? So, there we have it. She has to hand over her discovery. She has to hand over her notes, her journalistic notes. As I said, they can hand over notes. You can hand over all your research and all your notes without actually... Will KJ Sim have to prove somehow that she's a journalist? That's a good question. Well, from what the wording of that... according to the wording of what the judge said, that she hasn't been asked, there's been no... they haven't been asked to make a determination whether she's a journalist or not. Now, if you actually also look at her words previously, it says that she runs social media accounts. She never once said that she was a journalist. She didn't say she is responsible for whatever. She said she runs several social media accounts. So, and then she said based on what she's read, what's been submitted, what's been said in court, the judge isn't going to be Googling her or anything like that. The judge is looking at everything that's been filed in court and what's been said in court, transcripts of court. That's all the judge is going to base that's all that they're basing it on. So the fact that they keep talking about journalistic privilege, the judge has said, well, as the court's not made a determination that she's a journalist. And if you remember, the previous judge said she may be a journalist. It could be perceived that she's a journalist, but it wasn't a determination that she was a journalist in the court. Now, I would think that if you're going to take that line, you need to prove it. But again, I don't know what the proof is for that claim. But also, if you note, the judge did say, even if you were a journalist, under this law, you still have to produce notes. So she's got no way around it. She's got no way around it. Yes, it was plausible. That's correct. Yeah, plausible. It is plausible. She didn't say she was. So it said here, let me just take this on again. Let's just go back here again. So this judge said that she runs several social media accounts, okay? And she has hundreds of thousands of followers, particularly on Instagram and YouTube, okay? So that is that. It doesn't say she's a journalist or anything like that. So it says that she's. The other thing is that there's no denial that the accounts weren't. She's never denied that she made the posts. She's admitted to making the posts under that. So when we get down to here, the issue of whether or not Miss Paulson is a journalist has not been presented to or decided by the court. The only thing that's been said is that she said she's a journalist and is covered by journalistic privilege. To the extent the defendants maintain that the sources of some of this information are confidential informants or qualify as journalistic notes, they can provide that information to plaintiffs pursuant to a privilege log. KJ will be put in her place. She doesn't have proof of anything she has claimed. The judge will know she has an ounce of journalistic integrity, says Terry. So that, I think, is the most important point here, to be fair and honest, that the court has not determined if she is a journalist or not. The only person who has talked about being a journalist is herself. And then the court says that even if it is, even if the details of her confidential informant are to be kept secret, there is a provision in this to say that they can do a privilege log. So I'm just going to search this up. Just give me a minute. Let's have a look, because I like reading court stuff, as you know. I'm sorry, I'm not as great as Casey Joy at all of this court stuff. So this is under the Rules of Civil Procedure, and it looks like it's a new provision because, you know. So this is the disclosure. Okay, so we're looking at F. Hang on. A, initial disclosures. Oh, we've got to go down to F. What was it? D. What was it? 2602F. 2602 F. Here we go. Here, F. I'll try and make it. There's claims of privilege or protection of trial preparation materials. So 2602F, Part 1, when a party withholds information otherwise discoverable under these rules by claiming it is privileged or subject to protection as trial preparation material, the party shall make a claim expressly and shall describe the nature of the documents, communications, or things not produced or disclosed in a manner that, without revealing information itself privileged or protected, will enable other parties to assess the applicability of the privilege or protection. And 2, if information is produced in discovery that is subject to a claim of privilege or of protection as trial preparation material, the party making that claim may notify any party that received information of the claim and the basis for it. After being notified, a party must promptly return, sequester, or destroy the specified information and any copies it has, and may not use or disclose information until the claim is resolved. Any receiving party may promptly present the information to the court under seal for determination of the claim. If the receiving party may promptly present the information to the court if the receiving party disclosed the information before being notified, it must take reasonable steps to retrieve it. The producing party must preserve the information until the claim is resolved. Now, what does that mean? So Part 1 means that you can reveal the info, so you are able to disclose the information without disclosing the source, right? Or 2, you can file it under seal, and so that nobody sees it and everybody reads it, and once it's read, it's destroyed. So the judge is saying that, first of all, the court's not determined whether she's a journalist. And anyway, under this 2602F, it can all be disclosed and protected. So there's essentially, the judge is saying there is no excuse really for her to be withholding this confidential information, because under the 2602F, there's protections for it. Hello, short order cook. That there are protections to this. So she doesn't need to hand over. All they need to know is that there was enough research done that the sources were credible. They don't need to know who gave the information, just that the information received was correct. So that is what's going on. So I mean, as I said, to me, this is the most damning part of this. This point 7 is the most damning part of this, because she can no longer say the court's determined that she's a journalist. Katie thinks she knows everything. She thinks she's smarter than the court, says JMZ 72. Because this clearly states that it's not being presented to the court. Her own legal team has never presented to the court, here is the proof that she's a journalist and she's a journalist. And the court's not decided whether she meets those rules to be a journalist and therefore to even have journalistic privilege. We just keep reading that she's protected by journalistic privilege. And here, the judge is saying, I can't see anything So remember, she said, based on the files, records, and pleadings. So based on files, records, and pleadings, the judge could not find anywhere that that the idea of KJ being a journalist has been presented to the court, or that the court has decided that they are a journalist, that she's a journalist, and therefore protected. So remember, files, pleadings, and hearings. There's nothing on the court record about this. There's lots on the court record to say that she's covered by journalistic privilege, but nothing about the fact that she is a journalist or whatever their benchmark for a journalist is. What she has stated, and we've got to go all the way back up the top here again, that she runs social media accounts. She runs social media accounts. That is what the judge has determined as a fact. She runs social media accounts. She posts on social media. And it's interesting that there are 5 lines for that, and there's only 3 lines for that. So, yeah, so there we go. And by her own admission, she has a massive social media presence and has discussed the plaintiffs on several platforms. And it's the sources and veracity of that information is relevant to many of the claims asserted by the plaintiffs. So we've got the proof. Yeah, well, look, hi, Nikki. So she did, they have to compel to some discovery as well, but she has had a number of there's a number that she didn't get. She's had denials where 7M got all of theirs, got all of their motion to compel. And this is a very interesting line. By her own admission, Ms. Paulson has a massive social media presence and has discussed plaintiffs on several platforms. The sources and veracity of that information is relevant to many of the claims asserted by the plaintiffs. So she has to hand over her notes because, again, the court has not determined whether she's a journalist or not. And even if she was a journalist, they can be submitted as privileged. They've got that she's got to hand over how much money she's made. So essentially she's got to prove, I reckon we could write her response by going back and reading all of her winning comments from the last 4 wins, winning. So, yeah. So that's where we are at. So there are, as I said, there are a few things, but I don't think there's a lot more rejected on her part. Some of the stuff that she wanted was ridiculous. And I can't remember what 6 and 7 was, but I know she wanted bank statements and everything. And, her honour said, well, you can only have it from this time. You just can't have their whole life in bank accounts. So plaintiff's motion to compel is granted with respect to all disputed interrogatories and requests for production. Plaintiffs got everything they asked for. All right, everything. I can't remember if they did ask whether she buys subscribers. I think they did. I think that was one of the things that they did ask for. And she got Motion to compel granted with respects to interrogatories 10, 11, 14, 15, 16, 17, and 19, and the requests for production 9, 14, 20. Granted in part with respects to requests for production 6 and 7, and the rest denied. So this is going to make the scheduling conference on the 19th of March quite exciting, because I don't know, I'm assuming that by then, all of this information, I'm assuming that there'll be a time frame that this has to be all done by, and hopefully by the time they get to court again, they will have all the information. Remember, all of that discovery information is privileged anyway, because 7M wanted it to be a privileged, because of the fact they knew that somebody had a big mouth and would go and chirp off and tell everybody all the secrets. And we've seen in recently that that's what she's been doing. She was talking about 7M. And I said last week that I felt that she knew something was coming and it wasn't going to be good, just by the way she was going off. She had the tantrum before we knew officially what the result was. So already knew it was going to be bad. How is she going to? I can't wait to see. Well, we probably won't see them, but to think that her financial information is going to have to be now submitted to court is going to be very interesting, and the money that she's made from it. Anyway, so that's where we are with this. I actually have to I've just got to take an important phone call. So I'm going to leave it there. But as I said, I just happened to check and saw it was on, and I just went, ooh, 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 and got a bit excited. But thank you, everybody. Look, if you've got any questions about what we've gone through, please comment below. Remember, I am just a law student. I'm not a lawyer. I'm a law student. I will do my best to answer. And if I don't know the answer, I will find a place that you can get the answer. There are lots of law reference sites that I have access to. EKC is going live in 20 minutes. That's great. Yes, well, EKC is going live in 20 minutes. And I'm sure she's going to discuss the same, because I guess these have just dropped. So anyway, yeah, so how exciting is that? So I guess I'll catch you on in EKC's chat. Anyway, thank you for watching me. If you could do me a favor and hit like, maybe subscribe, and I'll see you